Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss regarding the jurisdiction of the trial court. Normally, in cases of 498A, that is harassment or cruelty, dowry harassment, in such cases, you may be knowing, according to section 198A, the prosecution for offences under section 498A shall be taken up only by the complaint made by the person aggrieved or father, mother, brother, sister or any interested person with leave of the court. So normally the related persons or she has to give the complaint, then only it has to be taken. That is 198A. Even 198 also says almost on the similar lines. This is the jurisdiction to take up the investigation, right? So as regards the trial, so yes, it can be done by the court in which limits the woman is residing, the victim is residing. This is what is enunciated by two judges bench, Honorable Justice Lav Nageshwara Garu and Hemant Gupta in the case of Ruhi versus Anees Ahmsd 2020. Ruhi versus Anees Ahmsd 2020. Actually, this Ruhi, she married Anees Ahmsd. Actually, she was converted into Islam. Actually, even though she is a Hindu, she was converted to Islam and then only the marriage was celebrated. Right? So she married Anees Ahmsd. Of course, differences cropped up among them and ultimately she filed a case of 498A against the husband in Delhi. Actually, some place in Delhi she has filed the case. Yes, they have taken up. But later, what the respondents, that is Anees Ahmsd and others, did was they have applied for transfer of the case before the High Court of Delhi. So what happened is, entire incidents they took place in Meerut. After marriage, she went to in-laws house in Meerut where she was subjected to dowry harassment. So therefore, basing on the ground of jurisdiction that the entire offence has taken place in Meerut and that too, the witnesses, most of them are living in Meerut. So therefore, the court, trial court or the High Court has transferred the case to Meerut. Now what is happening is, this woman who filed the case, she has to go to Meerut all the way from Delhi. Not only the financial expenses, the threats given by the husband and his relatives to this victim. She is a single woman, she has to go to Meerut, she has to attend the court. So normally court may not give 24 hours protection to this woman. Even though they order the police to take care of this woman, it's just not possible because in India, the Victims Protection Act has not so far come into existence. The compensation to the Compensation Act has also not seen the light of the day. Only in CRPC or victims compensation we tell in the words, but there is no specific act for this person except the Motor Vehicles Act. Of course, some place in CRPC, section 304, you can find it. But anyway, she is terribly afraid to go to Meerut because husband and relatives are there and they are threatening her. So therefore, once again, she filed a case for transferring to Delhi court. So High Court refused. Ultimately, the matter has come before the Supreme Court. Supreme Court stated that actually, according to 198 or 198A, who has to give the complaint? The victim. From where she has to give the complaint? Number one, where the harassment took place or where they last resided together. సో ఎక్కడ హెరాస్మెంట్ జరిగింది, లేదా భార్య భర్త ఎక్కడ కలిసి ఉన్నారు, లేదా వేర్ షీ ఈజ్ రిసైడింగ్. నౌ షీ ఈజ్ రిసైడింగ్ ఇన్ ఢిల్లీ అలాంగ్ విత్ హర్ పేరెంట్స్. సో దేర్ఫోర్ ద కేస్ కెన్ బి ట్రాన్స్ఫర్డ్ టు ది ఢిల్లీ Karaktuma Courts, Supreme Court. Basing on the celebrated case, please don't forget this case, Rupali Devi versus State of UP 2019, 498A. Yes, definitely. Basing on that case, now Honorable Supreme Court of India transferred the case from once again back to Delhi. In this connection, Supreme Court mentioned regarding section 179 of the CRPC also. 179 says where the offence occurred and the consequential effects took place. So, as a result of the harassment, the offence took place in maybe in Meerut, but the consequential effect is in Delhi. She is now staying in Delhi. She is suffering for food. Of course, she is dependent on parents. Normally, people will suffer. So, the consequential effects are there. Therefore, in Delhi, as per section 179, where an act is offence by reason of anything and a consequence which has caused, the offence may be inquired into or tried by a court within whose local jurisdiction such thing has been done or such a consequence has ensued. So, consequential effect, you can also take this. So, basing on section 179 CRPC, yes, the case can be transferred. Ultimately, Supreme Court held that the case can be taken up at a place where she resides with her father. Please remember. So, please remember these sections. Of course, you all know about section 498A, and whenever 498A comes, please don't forget the celebrated case of Anees Kumar versus State of Bihar 2014 regarding arrest. As regards the jurisdiction or who has to file the complaint, you have to go to section 198 CRPC. As regards the trial, you have to remember section 179 CRPC. That is what is enunciated in this case. So don't forget to remember Rupali Devi versus State of EP 2019 and present case Ruhi versus Anees Ahmsd 2020. Very good judgment. Please read them and enrich your legal knowledge. Thank you very much.